So we'll try to close by 3:40. So computer related inventions can be patented apart from the known softwares or improvements to the known static kind of applications. Like we normally see inventions means technology inventions means all about mobile applications. Again, this mobile application, the first browser or maybe first marketplace for the layout of the marketplace, eBay.com got a patent. It is way back 50 years back, when there is no product being sold via a computer. Even product information is not been broadcasted through computers. Then at that stage, so eBay had a browser, ebay.com as a domain. That is the first marketplace. And he listed a couple of products, and he organized a bet on the product to buy. Bidding. So that is his two inventions. One is the creating a marketplace through internet, and then a bidding, online bidding, so that people can participate and the maximum bidder will get the product. So after these two things, so the evolution happened, and now after Amazon, after anyone else, so all the aspects of the marketplace, selling a product or service is obvious. So someone coming up saying like I'll sell organic milk, I'll sell pet food, I'll sell plants. Yes, there is no one. For our availability in India, maybe otherwise in Telangana, there is no one who is actually coming to our place and maybe giving or selling our service which is like this, like which is not available on other platforms like on Amazon or someone. But that doesn't give us a patent, because technology behind on the platform, whatever the platform we are preparing, the technology has no uniqueness. Only the business has that uniqueness. Yes, if the business has that uniqueness, you just first enter into the market, and we cannot actually ask for a patent for it. Only the brand name, example, all your brand names can be trademarked. So, and with that registration of the name and different selling criteria, you have to enter into the market. I'm relating that example with this, but I don't know much about your status, but if you have anything unique, product-wise, service-wise, we can detailedly evaluate, and then we'll see whether we can actually file a patent or not. And this is the other aspect, like tiny treats, he's talking about tiny greens. So if he is actually infusing curcumin or maybe turmeric in his greens, for example, he's growing moong greens, and within it, like for example, he is infusing turmeric for the benefit of some immunity or anti-inflammatory or something else. So that process will become patentable?
No, any food or
it may become a patentable subject matter, but we need to understand this section of traditional knowledge, where the raw material or the ingredient that we are infusing has that benefit, inherent benefit. By infusing, if we are actually doubling it or increasing that benefit, then we can go for a patent. But not only by infusing, having this benefit to that. So this is the patent certificate actually. So after grant, we will get a certificate. So just for a view, and this is the flow. We can start with search. I told, like after that, like filing, we can start with the provisional application, and then converting this provisional application to complete application within a year. And within no time, if we ask for examination, as I told, examination can be asked along with complete application also, or we can take some time to ask the examination. And the maximum time, now the average maximum time, if we are doing whatever the jobs we need to do within no time, means like if we opt provisional also, if we can complete filing complete specification within a month and asking for early examination, then within a year we can see the result of the application. And these are the different entities, like women are given early examination option, small entities or MSMEs are given early examination option, government institutions or IPFCs like this trade center are given early examination option, startups are given early examination option. So with this early examination option, like the last year, like Indian Patent Office disposed 1 lakh applications. Not all filed in the same year, but whatever the pending applications are there till now, they disposed more than 1 lakh. The grants are 1 lakh. Last year, patent grants from Indian Patent Office are 1 lakh, more than 1 lakh. This is a history. Like no patent office till now, even China Patent Office or US Patent Office.
Grants means to provide money, right?
Patent grant, patent registration. Here we call patent grant is the registration. So this is the approximate cost to file patent in India. So patent search approximately 15,000, people charge up to 25,000 also, some agencies. And drafting and filing, the competitive price is 40,000. This is the professional fee, which is star marked, is the professional fee, and towards the government fees are 12,100. For startups under the Startup India scheme, so drafting and prosecuting during the examination, whatever we charge, so that will be paid by patent office itself for recognized startups. So the only one-time patentability search, if that is required, so that is only the cost. Otherwise, like only the 12,100 is the total fee, which is government fee forever for you to file and get it prosecuted. And if it is trademark, it is only 4,500, and there won't be any professional fees. So total number of applications filed in India, we already saw these, and why, like these are the Telangana applicants and Indian applicants in total. So just to have a percentage look, we are 5%. That is a considerable number. So, and within that numbers, like we ourselves are also doing good. So we are in the 17th position in India in filings, representing different institutions, government organizations, education institutions, startups, MSMEs, and other natural persons also. So this is the foreign route. After filing in India, if you want to have a right in other countries also, the best way is to take a PCT route. PCT means it's not an application for grant, but there is an entity called WIPO, World Intellectual Property Organization. What this entity's job is to combine or bring all the patent offices to on one guideline, and this guideline is that applicants are given some time to decide and plan their filings. So within a year, if a startup can file this PCT application, the startup will get 18 months more to decide and file in other countries. Why this 1 year or 18 months, total 30 months, why it is required for startups to decide and they file their applications? Because we don't know whether we get a patent grant. But to try, we filed in India or in one country first. Or wherever we, even Indian entity, there is no need like we have to file it in India. If you feel like you are a startup in India, but if you feel like whatever you are developing is worth selling in USA, then being here, working here, not needed like you have to file it in India, because like you find there is no need or there is no market in India. You find only market in USA. For example, someone inventing a gambling machine, which is not legal in India but legal in USA, but you thought of, you had that idea and you developed a product, and there is no point actually filing in India. You can file it in USA or in any other country. So your first application will become your home country application. From there you can plan your PCT application, and to get the first grant or first application processed, this 30 months is required. The average time to get an application processed is 30 months worldwide. So for that reason, this PCT came into picture. When people are fighting in between, like Means if you want to file, the first initial rule is wherever you want to file, you have to file all the applications on the same day. That is the rule.
In all the countries.
Yes. So from there actually it came up. The PCT came up. From there actually the 1 year condition came up. And then again 1 year is also not sufficient for a startup for planning their IPs. Then the PCT came up. So now it is 30 months by having a PCT application filed. So you can plan your foreign applications. So key benefits are actually wider coverage and cost saving, and to streamline and plan the filings. So these are the average costs after PCT or directly. So it is something like in USD, the cost in India it is only by taking Startup India advantage or even not taking Startup India advantage, it is around 70 to 80,000 is our cost to file and see whether you get a patent or not. But not the case with all the countries. So India is the cheapest when cost wise, if you see, when compared with all the countries, including Sri Lanka, Pakistan also, their filing fees are less, the government fees are less, but the service fees is more because the professionals are less and people practice are less. So for that reason, sitting in India, if you want to file an application in Sri Lanka also, it is costly. So these are the optimized costs actually, and if you file all these countries, it is something like, for example, why I gave this slide is, if you calculate all these costs, it is around $10,000. That means around 8 lakh rupees. It covers 80% of the trade market. So no need of thinking of 194 countries. No one does this. Even Microsoft files only in these countries.
Highest volume exits here.
80% market. And apart from this, like after UAE, they may consider filing in, like why UAE is like, UAE is the costliest, and all the 7 other countries, UAE, Saudi Arabia, Oman, all those are costly because not the government fees is costly, even government fees is costly, professional fee is more costly. Even compared with USA also it is costly. So European Union application will cover 34 countries, whole of the Europe, and then Israel, Singapore, Australia, Korea, Japan, China, Saudi Arabia, UAE. So these are the technology markets as well business markets.
Sir, if we filed a patent in China and we can expect that they don't copy and produce.
Yeah. It is far better than India. We are only talking about applications filing and getting a grant. Enforcing a right in India is hell. There only you need only one complaint in a police station.
Oh.
They'll take care. It's not for us, right?
Yeah.
China. We cannot see. We should not see like from our perspective China. You have to see in their perspective.
Their rules and regulations.
So if I paid,
They won't discriminate. They won't see like you came from India and complaining. Complaint is complaint. Here, like for example, this is the case, and I will give you one example. We are fighting in district court here in Rangareddy. There is a clear case of copy. We got a grant in India. We got a design registration in India for the product, and we have this design registration in more of the lot of countries also. We got in more than 20 countries. After getting a registration here, the same product, like wherever is market, we filed and got registrations in 20 countries. By showing all the 20 certificates like this also, judge is not looking at them. He is only looking at the opponent counsel. We are asking at least to give a provisional order, the initial interim injunction order. He is not giving because he is not understanding. He is not trying to understand also. The copy is by an ex-employee.
It is very obvious then.
Yeah.
It's very obvious.
Not even, after seeing this PPT or listening to one session like this, seeing the Patent Act and the provision in the law, anyone will sign on the order, interim injunction. After that we'll see. We'll see both parties' argument after that. First, I am giving a right, the provisional right to the patentee. Because he is showing the product, he is showing Indian grant, design grant, and 20 countries grants, and she is an ex-employee, and she he's not giving an order. So design, so typically for the shape of the design, this is the best example or oldest example, 1915 granted in US, the Coca-Cola glass bottle. So for example wise, like we show this, everyone in our fraternity will show this. So the shape of the product, you can see the bottom view. So in India also, if you have a design like this, so we have to give the perspective view, front view, rear view, side views, bottom view and top view. So these exact views if you have of your product, we can actually file a design application. This is not that critical when compared with utility patent. This is a much easier thing, and also trademarks also much easier things. Design of the or shape of the product can be protected under trademark also in India, even in other countries. Either you opt for a design patent, or you can opt with the same brand name, you can opt for the trademark also. In trademark also there is a separate application, apart from word, there is a separate application for shape of goods.